legal language. In this lesson, we shall discuss the classification of laws and legal system in India. Introduction. All the laws are not alike, depending on their nature, scope, extent and application. They can be varied. In this lesson, first we shall focus on the classification of laws as recognized in the modern legal systems, followed by the system of justice and the system of law prevalent in our country, succeeded by hierarchy of courts, tribunals, ADR systems and with special reference to Lok Adalats. As far as the system of justice is concerned, in modern times it can be either inquisitorial system of justice or adversarial system of justice. Inquisitorial system normally denotes a system wherein the state, the courts and others play a proactive role in finding out the truth. Especially the courts, they will be exercising the magisterial powers more. Sometimes they may also play a proactive role. Similarly, the police, apart from their traditional or conventional policing functions, may also try to discharge certain magisterial functions. And the famous saying that any admission or confession made to a police officer is not admissible may be confined to only few countries like India. In other countries, the police also may have the magisterial powers. In India, such powers are given only to certain high ranking officials, that too under certain extraordinary laws like the preventive detention laws. When it comes to the adversarial system, it is presumed that there is an adversity or litigation or simply stated lists between two or more persons who can be called litigants, and normally the courts do not swing into picture or they do not exercise powers on their own or suo motu powers unless the litigants approach the court. Only when the aggrieved party approaches the court will make an attempt to settle the dispute. As stated under the US Constitution of 1787, there must be a case as well as controversy, and the primary function of the courts is to determine cases and controversies. In this context, it is to be noted that India follows mostly the adversarial system of justice. The courts normally do not take into cognizance or take cognizance of any dispute unless it is brought before the court in its jurisdiction. Exception could be in the case of public interest litigation, wherein some of the active judges like P. N. Bhagwati or Justice Krishna Iyer used a jurisdiction known as epistolary jurisdiction, wherein even a postcard addressed to the Chief Justice or any other judge was treated as a public interest litigation and the process was initiated. Barring this, the courts normally do not take cognizance of any disputes or any issues of the citizens getting aggrieved by various developments. Now, let us try to understand the hierarchy of courts in India. In fact, the courts in India could be broadly classified into two categories. First, the higher judiciary, second, the subordinate judiciary. The higher judiciary consists of the Supreme Court of India, established under Article 124 of the Constitution of India, and also the various high courts established in various states. The Supreme Court and the high courts put together constitute higher judiciary in India. On the other hand, there are number of subordinate courts which are part of the lower judiciary in every state, right from the district court level and downwards. And these courts forming part of the subordinate judiciary could be either civil courts or criminal courts or even special courts. For instance, the civil courts all over the country are divided into the following hierarchy at the district level. At the highest level is the district court headed by a district judge or additional district judge, followed by the court of senior civil judge, which is followed by a junior civil judge, and in certain cities there are also small courts known as small causes courts with a very negligible pecuniary jurisdiction. So, at the cost of repetition, it may be understood that civil courts in India could be the district court, court of the senior civil judge, the court of junior civil judge and small causes court. On the criminal side, at the district level, we have the district and sessions court, also known as sessions court, then followed by the assistant sessions judges court, followed by the judicial magistrate of first class, again followed by judicial magistrate of second class. Then at the bottom we also have certain courts called courts of executive magistrates, wherein some of the authorities exercise powers as the executive magistrates. Then tribunals in India. Apart from the courts, we also have certain hybrid courts or quasi judicial bodies established in India called tribunals. Tribunal means a seat of justice, and the tribunals are established in India now under the Constitution by virtue of Article 323A and 323B. There are administrative tribunals for service matters, you can call them service tribunals, like Central Administrative Tribunal, State Administrative Tribunal and Joint Administrative Tribunals. There are other administrative tribunals for certain special purposes like the tax tribunals, customs tribunals or intellectual property appellate tribunal or competition appellate tribunal, etc. Then the advantages of tribunal are that they consist of both the judicial members and the departmental or technical members who will apply their knowledge in ensuring that the justice is speedy, informal and inexpensive. Then apart from the tribunals, India is also increasingly adopting the ADR system in India right from the good old days, that is alternative dispute resolution, wherein the parties are at liberty to either prefer arbitration, mediation, conciliation or any other form of out of court settlement, which will become final. And this ADR system has certain advantages over and above the judicial dispute resolution. One important noticeable form of ADR is Lok Adalat, which is also called judicial settlement, which constitutes something called court annexed ADR. In this Lok Adalat, not only the judges, but also social activists and even lawyers also take part in ensuring that justice is done to the litigants whose cases are pending before the courts. Of course, certain serious criminal cases like murder, rape, dacoity are not part of the Lok Adalat system and no Lok Adalat is competent to look into them. Now, let us understand the classification of law. All the laws are not alike. Law can be classified depending on its nature, its applicability, so on and so forth. For instance, one subclassification could be codified and uncodified laws. Codified law is the law which is subjected to codification. Codification normally denotes approval by the competent legislature when a proper draft of a law is introduced in such legislature. For example, before 1833 in India, there was no effort made to codify the laws. Most of the laws were dependent on the ruler, the religion of the ruler and other factors. When the first law commission was appointed during the British regime, when William Bentinck was the Governor General, it was given the task of codifying the laws in India. Today, Indian Penal Code 1860 is one of the best examples of codified law, followed by Indian Contract Act, Transfer of Property Act, Indian Evidence Act. There are so many, and codification offers consistency, certainty and uniformity. Therefore, the scope of ambiguity is very less, either in interpreting or in following such a law. But there are certain laws which are called uncodified. There may not be any systematic arrangement or approval by the legislature. Still they constitute law. For instance, we have a subject called law of torts. Torts are also called civil wrongs, is a subject which primarily consists of the judgments delivered by various courts and the principles laid down by such courts in relation to the civil wrongs like vicarious liability, negligence, malicious prosecution, strict liability, so on and so forth. Even today, law of torts continues to be an uncodified law. Some of the personal laws are yet to be uncodified. For instance, a major part of Muslim law is uncodified. Similarly, certain other laws like administrative law is nothing but a compendium of many of the principles laid down by the courts. This is the first subclassification, that is into codified and uncodified laws. The second subclassification could be classifying the law into public and private law. Public law is that law which regulates the relationship between a citizen and the state. The state, when it determines the rights of the parties or imposes the duties on them, it is done in the form of a law. For instance, Indian Penal Code, the Constitution, Right to Information Act 2005 also is an instance of public law. Private laws are those laws, even though they are made by the parliament or other state legislatures, they will be determining the rights and duties of the private citizens. Here, the government authority may not be one of the important aspects. For instance, property law. When any property transaction takes place, whether it is sale, mortgage, lease or gift, then the rights of the parties will be determined by the Transfer of Property Act. Both the parties may be private parties. Incidentally, even if the government is a party, still the rights are private rights. Contract law. Contract law also is a private law because the contract need not be between the government and a private citizen. So, there are two sets of laws, public laws and private laws. The third kind of law could be secular law and personal laws. India is a secular country. We do not have any official state religion. The Constitution of India guarantees right to equality in matters of religion. Every citizen can practice, propagate and profess any religion. He shall have the freedom of conscience, and therefore, majority of the laws in India are made applicable to all the religions. For instance, property, contract, constitution and many more. But by the side of secular laws, we also come across personal laws. These personal laws deal with the personal matters of the citizens. They may include the marriage, the succession, inheritance, dissolution of marriage, custody, guardianship, so on and so forth. In the absence of a common civil code or uniform civil code in India, every person who follows a particular religion has an option either to follow his personal law or a secular law. Therefore, a Hindu is governed in terms of marriage by Hindu Marriage Act 1955. A Muslim is governed by the principles of Shariat. A Christian is governed by the Christian Marriage Act 1872. A Parsi is governed by the Parsi Marriage and Divorce Act of 1936. Marriage is same, but the rights will be different under different personal laws. Same is the case with regard to other personal matters like succession, adoption, maintenance, so on and so forth. Another important classification of law could be civil and criminal laws. A civil law normally deals with private rights of the parties, which may be contractual rights or other rights. But when it comes to criminal law, this is the law which deals with crimes, and the crimes are understood as commissions or omissions which are made punishable under a law, which affect the entire society. not the victim himself. Whether it is Indian Penal Code, Criminal Procedure Code, certain parts of the Indian Evidence Act or Juvenile Justice Act, there are so many criminal laws, major criminal laws, minor criminal laws, and since they occupy the relationship between the society and the individual, the government will be duty bound to play a very important role in bringing the culprits to the book and to prosecute them and to see that they are awarded the due punishment under the criminal law. Another classification could be substantive and procedural laws. Substantive law is that law which creates rights and obligations. For example, Indian Penal Code, it creates certain rights as well as obligations. Contract law, which creates rights and obligations between the parties, or property law in the form of the Transfer of Property Act 1882. So, any law which creates certain rights and obligations is known as substantive law. In contradistinction with substantive laws, we also have procedural laws, also known as adjunctive laws. Procedural laws deal with the procedure to enforce the rights and obligations created under the relevant substantive laws. The best example could be Criminal Procedure Code of 1973. When any offence is committed by an individual under substantive law like Indian Penal Code, the offender will be prosecuted, tried and punished under a procedural law like the Criminal Procedure Code 1973. There are many such procedural laws. For example, in civil matters, it is the Civil Procedure Code of 1908. So, when a private party feels that his rights are violated under a contract or in terms of property, he can file a suit, but the procedure for filing the suit is regulated by the procedural law called the Civil Procedure Code 1908. We can also discuss about another subclassification of the laws, international and domestic laws. International law is that law which regulates the relations between one nation and the other nation, and international law may not be a true law for the simple reason that there may not be any sanctions as far as the disobedience of such international law is concerned. So, if any treaty obligations are not discharged, if any contractual obligations are not performed, or if there is any threat to international peace and security, in such cases enforcing the international law would become a little difficult when we compare to the enforcement of the law in a domestic jurisdiction like in a state. Whatever may be the source of international law, whether it is the statutes, the treaties, the peremptory norms called jus cogens, still international law is a law of consensus. Only when the parties agree to abide by the international law, then only the enforcement will be possible. But in this age of globalization, where one nation depends on the other nation, without having an international law, the international relations cannot be maintained effectively. So, there are umpteen number of conventions, covenants, treaties, bilateral and multilateral agreements, free trade agreements, so on and so forth, which constitute the international law, and every sovereign country can determine its own role as far as international law is concerned. Now, coming to the municipal law, also known as the domestic law, or you can call it even national law, it is nothing but law of the land, and it has a territorial jurisdiction. For instance, Indian law is applicable only within the territory of India, or where there is an entity which is under the control of India. Barring that, Indian law cannot be applied in other countries. For instance, there are certain fugitives who run away from the law. They may take asylum in other country. India may be trying to get them extradited, as could be seen in some of the recent developments, but Indian law will not be applicable to bring somebody back either from England or from Pakistan or from Dubai, unless there is some kind of agreement between our country and the other concerned countries. We can't apply the Indian law in respect of an Indian, but taking refuge in a foreign country. So, national laws are confined to the territorial limits of the concerned nations. So, these are some of the different kinds of law which we encounter in our day-to-day activities.